Okay, and with that, let's call our first case. The first case is Bonter versus Progressive Marathon Insurance Company. This is a mini oral argument on the application. Both sides have 15 minutes. Mr. Hicks, both sides will get 2 minutes of fire-free zone. If you would like to reserve time, you may do so. Just let us know, and we ask that you keep track of it. But proceed when you are ready.
May it please the court, Steve Hicks on behalf of plaintiff appellants Cody Bonter and Caitlin Jackman. I'd like to reserve 2 minutes for rebuttal if I can, and I'll waive the free fire zone. I'm happy to take the court's questions, especially given that we argued Pena last term, so I know the court's familiar with the issues. At the outset, I wanted to just be clear that I represent Bonter and Jackman. I do not represent Williams. He's been unrepresented. Progressive assigned him someone in the tort case, but not in this case on the coverage issue. This coverage issue is significant to not only Bonter and Jackman, it is significant to Williams as well, who would be the person who would have exposure for liability if the limits are low. The court's asked two questions. The first question is same or similar to the question that was asked in Pena. And basically, we're dealing with auto policies issued before July 2nd, 2020 that extend beyond that period in which, beyond that date, and they provide only 2040 based on the terms in which they were secured. These are what we started to call them straddle policies at the last argument. I think that's a good term for them. So the question is whether the higher limits referred to in 500-3009 apply in this case, and that would be the 250-500 coverage that is now required in Michigan unless you opt out. So that's the first question. Second question is a slightly different question dealing with the specific facts in this case. Here there was a change in vehicles after that date of July, actually the July 1st, 2020 date. It occurred on like the 6th, just a few days later. And the question is whether that, along with a coverage summary that were provided to Williams, whether that would trigger the higher coverage limits. I think I can address the first question quickly because, of course, I did it in Pena. I did rewatch that argument, and the court addressed a number of things there. The text of 500-3009, I think, clearly supports our position in this case. I really honestly don't think that it can be read any differently. The Court of Appeals managed to do that by essentially lifting the dates that are used in sub A and sub B into the paragraph about delivery or issued for delivery. It's not where they appear in the statute. They appear and they are paired with the coverage amounts. And if there was any question about that, whether that was the legislature's intent, was that policies issued that may straddle this date, if there's any question whether the legislature's intent was to make sure that you had 2040 before the date and then the higher limits after the date, it's basically dispelled by their use of the words all of the following limits. All means all, has to have both. So while there is a caveat in subsection 1 that says subject to sections 5 through 8, it's important to know that 5 through 8 concern only the opt-out provisions that have to be offered to people after July 1st, 2020. These opt-out provisions have nothing to do with these straddle policies because it is specific to those. So,
Counselor, could you specifically address, opposing counsel spends some time on subsection 8 and that it renders if that subsection superfluous. So can you specifically address that?
yeah, so subsection 8, let me just pull the statute. Subsection 8 is part of the provision. The opt-out provisions, I'd say it doesn't apply. They do use slightly different language in that. They don't use the delivered or issued for delivery language. They use, if an insurance policy is issued or renewed, as described in subsection 1, and the person has not made an effective choice, then you're going to go to the higher limits. Again, my position is it doesn't really have any application here.
I'm sorry, your position is what?
My position is that it just doesn't have any application, this sub 8. That's true of everything 5 through 8 that has to do with the opt-out provision. What they are talking about there, and It's right in the first phrase of sub 8. After July 1st, 2020, this is what's going to be the deal. And so they're talking about policies, not straddle policies. They're talking about policies that are issued or renewed after that period of time. We have a slight question on that because of this issue with the coverage summary, and I'll come to that. That's the second question addressed here. But I guess the overriding theme that I'm trying to convey to the court, and in answer to your question, is that 5 through 8 really don't have any application because they're all about the PIP opt-out and how that's going to work. And if, the other side has suggested that I somehow render nugatory subsection 8. I don't understand how that can be the case. At the same time, we are having Court of Appeals decisions enforcing how the choice works. We've had a couple of those cases come down, one where there's been an effective choice, one where there's been an ineffective choice. They clearly have meaning. They're being applied. They just don't apply in this context. So that's my take on those. And it's interesting because in Pena, as these arguments developed in this case, defense argument kept shifting. First, they relied on Diff's earlier bulletin in which it quoted heavily from subsection 6, 5 or 6 of the statute. Didn't even refer to 8. It was only later that they shifted their argument to 8. And now that I don't really, 8 is probably where their argument should be because I think it raises more questions, this use of different language. But fundamentally, it's just not there for them because this all deals with something policies completely different than this.
If we accept your position and we conclude that the heightened liability limits of 30091 apply to contracts issued before July 2, will we not also have to conclude that the amendments regarding MCL 500-3107C, which limit PIP benefits, also apply to those existing policies?
No, I don't think so. I don't think there's really carryover between the liability provisions of the statute and the PIP provisions of statute. Liability and PIP have always been separate. We've had liability a lot longer, and we're sort of building and revising and amending on statutes that have existed before the No Fault Act was adopted. The only thing that's significant about PIP is that PIP reinforces the changes made to PIP, that you no longer have to have unlimited PIP. You can choose less than unlimited. Even in some circumstances, you can choose to have no PIP. The only reason that's significant is because liability increases. And when does it increase? It increases the day after on July 2nd, 2020. So anything
but that's
after,
why we're here. We're trying to decide that.
Well, I don't think there's any question that liability increases. I don't think that if the other side disagrees with me, they would simply make the point that, well, it doesn't happen instantaneously. It's a rolling system. As people get new policies, et cetera, new policies either issued or renewed, they have to make an election, and some of them aren't going to get PIP.
But weren't they all tied together? I mean, the reason for the increased liability limits was largely tied to the option to lower PIP coverage. I mean, wasn't that all part of the global discussion?
It is in the sense that they gave you the option to sue in tort to get whatever you can't get in PIP. In terms of the dates, the reason that's the operative date, in this case, I think I made that clear, but the reason as it pertains to PIP, it's operative in that it increases your tort liability. Dembski, the case that's going to follow us today, has a different question of can those schedules actually be applied sort of during that, to cases that occurred during that period. That isn't really the issue in this case at all, because liability and PIP have always been different. And while I see the reason the court would think that these should be heard together and argued together, there really is no carryover here, because the text in this statute is clear on liability. The reason for it, the public policy behind why they did it is clear, and there's no dispute that tort liability would be increasing over this period. And with Williams, we're talking about a guy that wrote secured coverage 10 days before the law was going to change. 10 days. Yet he's stuck in a policy that's 2040 through almost the end of the year. Way too little coverage for this increasing tort liability, which diffs is telling insurers, hey, you've got to modify those. You've got to do midterm endorsements, or you've got to issue new policies, because if people want that, you got to give it to them, both the PIP and the liability. So it's happening, and there's exposure, yet they say nothing. And this gets me to the second question. The second question is really about, hey, they issue this coverage summary, they put a new vehicle on that. Does that make any difference here? And I've answered it a little differently than perhaps the court intended when they asked it. The court asked, you know, what is that delivery of a policy? I think the case law is pretty clear, and I've conceded this, that I don't think that is a new policy at that point. I mean, people swap vehicles in all the time. The coverage summary, you know, I think it's misleading to say, here's your coverage summary, you still have this coverage, even though it's after July 1st, 2020, you still have 2040, because that's what you wrote back then. I can't understand why they are not informing their insured at that time, while they're issuing policies with the form that they have to use to elect coverage, which say you're exposed to severe financial consequences if you don't get enough coverage. Yet you're at 2040 for the next nearly 6 months in this case. And where
So what should they have done? They warned
Notify.
them, but then what?
They
A
had the-
10-day policy, or what should they have done?
midterm, and according to DIFS, and the memo that, or the bulletin that DIFS issued on July 8th, DIFS said you got to do a midterm endorsement or you got to write a new policy. One of those two things. Both of those would have worked. Both of those would have made it very clear, 250-500, everyone would be on the same page. And it's not like they didn't have the forms. All this talk of how hard it would be for insurers, they had the forms. They had the forms since January 1st of that year. They just didn't use them because they wanted to keep writing 2040 policies, because that's their market with this company, and that's why Progressive Marathon has most of these cases. I think there's only 4 that I know of. 3 of them are Progressive Marathon, 1 is Esurance. So that's why we're there. And so on that second question, if I can just drill down on that for a second, how do you get there legally? Because Kosky, the case I rely on, Kosky versus Allstate, talks about you know, informing your insured and the insurer having a duty, if they're going to reduce coverage, to inform the insured. Well, the other side's response to that is, well, we didn't reduce coverage. The legislature did that. Statutory, and the Court of Appeals agreed in Bonter. They said statutory changed the law. That's not going to get you there. I would say that's absolutely wrong, because Auto Owners versus Martin didn't deal with a statutory change, but it dealt with a change in the law. A case had come out telling auto owners, you can't keep writing these policies that dip coverage down to 2040. You write them for more, but you know that the coverage will be 2040. And on that, auto owners got tagged for the $1 million that they wrote and that they collected premiums on. And the court basically chastised them for continuing to write these policies that weren't in compliance with the law. Well, what law? It was common law. It was law that they made. So this whole notion that a statutory change is not a reduction of coverage and you don't have to notify your insureds. Sure, it's not exactly on point with Kosky, but it's unfathomable to me that you're not notifying the insureds of that. Sounds like the buzzer went off. I never get rebuttal.
No, you still have 1:48.
Oh, it's
if
a
you want to
warning
save it.
buzzer.
Yeah.
If there's more questions, I'll answer them now. If not, I'd prefer to have a rebuttal. Thanks very much.
Thank you.
Good morning. May it please the court, Jeffrey Garish on behalf of Progressive. The only way that this case differs from Pena is the wrinkle of the coverage summary being issued on a new vehicle. That was the second question this court asked the parties to brief with supplemental briefs and argue today, and counsel has conceded that they can't win on that issue. So that brings us to, this is the exact same issue as Pena. The only thing they argue in that respect is that because Progressive allegedly didn't offer new policies, therefore they can be punished by imposing the higher limits that otherwise wouldn't apply. But there's nothing in the statute or the law that supports that, which I think is why they weren't even asked to brief that issue. On the Pena issue, which is the same as the issue here now, I know 4 of you heard argument on this from the 2 of us once before, which there's nothing more enjoyable than listening to yourself orally argue something. 2 of you didn't get to hear it, so I'm going to try to change it up anyway. Let me just concede for purposes of argument that subsection 1 can be read the way they read it. The Court of Appeals in Pena found that there's no ambiguity when the statute is read in its grammatical context. I think what that means is when you consider 5 through 8, it removes any doubt about what was intended in 1, and that's the key. And 8 is key, as Justice Thomas asked. 8 specifically said, 8 is the only section, by the way, that addresses the issue of what are the limits on policies that are issued under 3009. 8 is the only subsection that addresses it. Subsection 1 doesn't address that. Subsection 1 simply addresses what insurers can and can't do. So let's say an insurer like Progressive issues a policy under subsection 1. You go to 8 to find out what the limits are. And 8 says, after July 1, 2020, an application for the issue, if an insurance policy is issued or renewed as described in subsection 1 and the person named in the policy has not made an effective choice under subsection 5, the limits under 1A and B apply. That makes it abundantly clear that this doesn't apply to straddle policies. Because if it applied to straddle policies, if limits automatically went up on July 1st, 2020, they wouldn't have said that. They would have said something like, for any policy in existence as of July 1, 2020, the limits set forth in 1 apply. Or they wouldn't have made any reference to the date. They would have just said, the limits in 1A and B apply to all policies issued under this section. But they specifically said after July 1, 2020, and it removes any doubt that that's what they intended. They only intended these limits to apply to policies issued after July 1, 2020, which, Justice Welch, is exactly what all the other statutes said. And the statutes have to be read together, which is also a clue to what the legislature intended. This is also apparent from subsection 6. And I think I haven't done as good a job as I should have talking about subsection 6. But the more they've argued, the more apparent it is that subsection 6 is completely contrary to their argument. Subsection 6 is the section that talks about what insurers have to do because of these new limits. And it directs insurers to advise their named insureds or applicants about these new limits and the option to go from 250 to 50. It also instructs insurers to advise their named insureds or applicants about the price for a new policy, a price for the 50 and a price for the 250, and it directs insurers to offer the option of taking the lower limit along with giving them the form. But here's the key. This is what it says. The very first part of subsection 6 says this: after July 1, 2020, on application for the issuance of a new policy or renewal of an existing policy, an insurer shall do all the following, and then goes through the options of what they have to do. Again, it makes it abundantly clear that this only applies, the insurers only have to do this on application for a policy after July 1, 2020. If the legislature intended these limits automatically to go up on July 1st, 2020, surely they would have said that for any policy that's in existence on this date, that's whether it's issued before or after July 1st, the insurers have to notify the insureds about this new limit that's going to be foisted on the policy.
What about the fact that the language says the applicant or named insured? Does the fact that they include the named insured suggest that there is an existing policy in which there is a named insured? Because
Right.
you don't have a named insured on an applicant.
No, that's right, but I think what they're saying is, that's why they talk about both application for a new policy or renewal. And I think the purpose, an applicant that's not a named insured would be getting a new policy. The only person that would be getting a renewal is a named insured. That's what they mean by that. And that's why the use of named insured in 5 doesn't do what the MAJ, their amicus brief, thought that was significant, but it's not when you look at 6, because it says on application for the issuance of a new policy, that would be for an applicant, or renewal of an existing policy, that would be for a named insured. Again, if the legislature intended these limits automatically to go up on the first, it would have been, I mean, it would, again, I use the term in Pena, what a head fake. I mean, these are essentially directing insurers, this only applies after July 1, 2020. Their argument is that when the legislature said in subsection 8, after July 1, 2020, the limits set forth in subsection 1 apply. And what they really meant is, for any policy in existence, the new limits apply, which is not what they said. And it would have been incredibly misleading. And that's also why DIFS interprets it the way we do. Now, CPAN, almost their entire argument is that DIFS interprets it the way they do, which I have to say I'm completely mystified by this argument, and Mr. Hicks mentioned it again today. He said DIFS issued this bulletin on July 8th, 2020, saying, insurers, you have to offer these new policies. You have to tell the insureds about these new limits and these new policies, and you have to offer them. Well, why would they have to do that if the limits already applied? The whole purpose of the bulletin was to make sure insurers were complying with 6. Subsection 6 is what says that after July 1, 2020, you have to notify your insurers on any policy that's issued after that date. That's when you have to notify them. CPAN argues that this bulletin applies to straddle policies. It's right in their brief. They said this proves that DIFS interpreted the way we do because they ordered insurers to, on straddle policies, make this offer to them. But that only proves that CPAN and plaintiff are worse at reading DIFS bulletins than they are at reading the statute. This is the DIFS bulletin they rely on. The first sentence says, on June 11, 2019, Governor Whitmer signed historic bipartisan auto no-fault legislation to lower costs for Michigan drivers, maintain the highest coverage options in the country, and strengthen consumer protections. This is the second sentence. And this is in CPAN's Exhibit A in their appendix. These changes apply to policies issued or renewed after July 1, 2020. DIFS has consistently recognized from the very beginning these changes only apply to policies issued after July 1, 2020. Insurers were entitled to rely on it, and they did. Mr. Hicks talks about Progressive as being, he implies that there's some kind of outlier. I've never heard of any insurer issuing a straddle policy that imposed these giant limits, 12-fold 2040 as of July 1, 2020. There's been no illustration of this happening by any insurer anywhere, probably because this is what the statute says, and this is how DIFS has interpreted it from the very beginning, and the insurers have relied on what DIFS said. And I'd also note, Mr. Hicks suggests, I think he even said today, that insurers like to write 2040 policies. No, they don't. They would much rather write 250, 500 policies. They would much rather write these higher rates if they could, but they can't. They're not even entitled to do that. And he also suggested that Mr. Williams was stuck in this 2040 policy that he took out right before July 1, 2020. That's the policy that he wanted. The people who are hurt the most by imposing 12-fold limits of over 2040 as of July 1, 2020 are the policyholders. No policyholder in any of these cases wants these limits. I can assure the court that Mr. Williams, granted, he didn't take a position in this case, but if he had wanted these higher limits to be foisted on him, he would have argued it. He didn't want them. In almost every case, as soon as they have the opportunity, these people elect the lowest possible limits. The only people that are benefiting from the position that Mr. Hicks and these amici are arguing are tort claimants. Insurers don't want it. Policyholders don't want it. DIFS doesn't want it. That's why the insurance groups that are the Insurance Alliance of Michigan that represents both insurers and policyholders is on our side on this, and the national group too. Nobody wants this except tort claimants, and I mean no disrespect, but it's really even just the claimants' lawyers. It's not even the claimants themselves, because the claimants themselves are getting unlimited PIP. They continue to get unlimited PIP. They don't need this. And that's important, because Justice Welch, you're right. All these changes went into effect only beginning with policies issued after July 1, 2020. Now, let me just address one other thing, and this is a question, a dialogue
Counsel,
that
from your viewpoint, what would be the tort liability exposure here if we agree with your viewpoint?
I agree. I think he's right. I don't disagree that the tort liability potentially went up as of July 1, 2020, because that's when 3135 allowed them to sue for it. But I think the legislature recognized that it was going to be a gradual increase over time, because they can't even get a policy that allows, they can't even begin to sue until after that date. And they can't get limited PIP coverage until after that date. So it's not until they start getting these policies with limited PIP coverage that the PIP coverage that's not included in their policy can be sued for tort. And I think the legislature recognized there's going to be a little bit of a lag, but they intended for all of them to take effect only for policies issued after that date. And CPAN is also...
But we have unlimited PIP coverage here.
Yes, well, yes, because they're, I mean, not only the progressive policy, but the claimant's own policies, to the extent they had them, would had to have had unlimited PIP coverage, because they would have been taken out before July 1, 2020. So they have unlimited PIP coverage until you can buy one with limited, and you can only buy one starting with July 1, after July 1, 2020.
Counselor, wouldn't it make sense for, if the legislature, if we're trying to imagine what they're up to have the default for the PIP coverage and the ability to opt out start on July 1 and the changes in tort liabilities? Everything's sort of starting on July 1 instead of one starting on July 1 and one rolling over time.
I'm not sure I understand.
So if they're both creating this default, why wouldn't our legislature want those to happen on the same day and not for, you're saying this one, the tort liability changes over time and sort of a
Yeah,
rolling
probably because they didn't want to foist these huge limits on policyholders who didn't want or need them. I mean, as of July 2nd, Mr. Williams didn't need a limit of 250. He was perfectly content to have a limit of 20, because it's going to be a very long time, and it's going to require a lot of, fortuitous circumstances for him to get sued by someone who didn't take a policy out with limited PIP until after July 1, 2020. So I think they did the best they could. And this brings me to a dialogue I had with Chief Justice in Pena, which is a very fair question. I think you asked, why didn't the legislature make this clearer in subsection 1? I think I'm not sure, but here's what I think is a pretty good guess. And it's they were trying to work off of the old statute. With 3107C and D and the other ones, they started from scratch and they made it very clear. With 1, they started with what was there. And if you can find it, we actually have a book that has the old version, so it's easy in our office. But on page 310, I'm sorry, on page 110 of my appendix, 110B, I've quoted the act, and you can see what they did. The initial statute in subsection 1 said, insurers cannot deliver, issue for delivery or liability with all that language unless subject to all the following limits. The word all was in the initial statute, so I'm not sure why they think the word all is so significant. And the limits were $20,000, $40,000, and $10,000 for property. That was the whole statute. Then when they tried to amend it, they broke it out. And I think the drafters probably never put it together that it could be construed in the way that the clever plaintiff's bar is construing it, to where they're tethering the limits not to the delivery date. But again, the clues from the other subsections in the they have no answer for the meaning of subsections 6 and 8.
But they didn't rely on clues or other provisions in those other provisions, right? They knew clearly how to say, after July 1, this is what happens. And they didn't include that. I get your point that they were working from an existing statute, but in later sections, they were able to specify when they wanted things to start and not, and they didn't include that language in 1.
But they did in subsection 8. That's where they clear it up. Because subsection 8 is the section that talks about what limits apply. They could have been, I'll grant, they could have been clearer in subsection 1 and rearranging it a little differently. But they removed all doubt in subsections 5, 6, and 8 because those talk about how they did not intend the limits to go up, or they would have said so.
Okay, thank you.
Thank you, Your Honors.
Just real quickly, 2 points. First of all, with regard to the second question, I mean, I've made the same argument since the trial court on them having to notify their insureds. The notion that Williams would prefer to have less coverage and a large judgment against them, I think is ludicrous in this case. He'd like as much coverage as he can get. He just doesn't have counsel here to say it because they didn't assign any. Second of all, with regard to that, also on that point, Williams, had they given him the form, had they notified him, he would have 2.5 times the coverage they're offering him now. Because he would have, even if he would have opted out and done the 50, which, okay, probably he would have had he been informed. We can't say that definitively. He should have been informed, but he probably would have. He'd still have 2.5 times the coverage. The problem and the dilemma here is there's no way to get to that the way the statute is written, because you have what they have to do in subsection 1, and then you have the opt-out, which they can do after July 1st, 2020 for policies issued or renewed. Now, counsel reads a lot into the after July 1st, 2020. He wants to say, what they're really saying here was any policy in existence. I mean, if that's where we are, I think we should just declare the death of textualism, because they are so far beyond the text, and they can't reconcile all of the following limits. All means all. The legislature could have taken that word out. They could have done any number of things differently, as counsel has told us. They could have said any policy in existence in the later sections.
Counsel,
They didn't do it.
I want to give you a chance to respond to the same question I asked Brother Counsel, just sort of the practical effect of,
Yep.
we've got unlimited PIP benefits, expanded tort liability potentially. Can you explain how that would impact this case?
You mean in this particular case?
Yes, in this
Yeah,
case. Like,
yeah.
it's a practical, if
Yeah.
we were to agree with.
Let me be clear on that.
Yeah.
These particular clients are entitled to unlimited PIP, and my understanding is they have received it and has been paid. So did it play out for them in particular? Are they going to be able to dump in their PIP claims into the tort claim against Williams? No, not in this case. Not in this case. But that's sort of not the point. They got lucky. Williams got lucky too in that sense, because he won't get hit for that. But he's not representative of everyone else that's out there. So the answer to your question is twofold. The facts in this case are what they are, but this court reminds us all the time that you're really doing the job to figure out the law for other cases that are out there. And we don't know what the gamut of cases are, and frankly, the other ones that are pending, I haven't thought to check whether they're getting PIP or not. But to make that ruling based on the facts in the case would be to ignore the legal interpretation that I think has to be applied here if you use the plain
And
language.
doesn't liability coverage cover more than just excess PIP?
Oh, yeah, I mean,
Right,
it's,
so
yeah.
so that exposure to, that would be protected by added liability coverage is
Yeah,
not
that's-
just for what they couldn't,
That's
what
a- you
the
know,
victim
and-
couldn't
and
get for
count-
excess PIP. But
Counsel's right. That's a large part of the reason here is there's just not enough coverage here.
Right.
Williams doesn't have enough coverage. He certainly doesn't have enough coverage if it's 2040. But the claims here are big, I think, on most of the cases that are pending. So hopefully that answered the question. I think I have the textualist high ground here on this case. I don't think their argument that it should be read in its grammatical context has any real legs. And with regard to diffs, you ask diffs a question on one day, you might get one answer, and another day you get another answer. I think their bulletin's pretty clear what their intent was. And even if it wasn't all that clear for the other cases, with Williams, he did change policies, get this coverage summary right at the same time, I think a day or two before the bulletin comes out. Why is no one there saying, hold it, we just dealt with that guy, we probably should have offered him the midterm endorsement or a new policy, because he needs more coverage for the next 6 months.
Okay.
Thank you.
Thank you. The case will be submitted.